All right. Ladies and gentlemen, this is the Juvenile Justice Committee of the Georgia House of Representatives, and I'm calling this meeting to order. First, we have a couple of bills on the calendar today. Senate Bill 8, Senate Resolution 7, and Senate Bill 64, which will be heard today. First, we're going to try to finish up Senate Bill 8, and there is a substitute. It is Senate Bill, let's see, the LC number that I have here is SB 8/CSFA/2. What was that? Where? Okay. Yes, sir. Well, sometimes the chair doesn't get that substitute.
Yes, you got it right. That's your number.
So I said, but I got it now. This is LC 296621S. And that's the version of the bill we'll be going from today. Okay. Yesterday, after several amendments, we have a substitute version of the bill that should be in all the folders. Does everybody have LC 296621S in their folders? Okay. All right. Now, yesterday we left, and there was a do-pass motion that had been seconded. But we have some further, and we were, the bill was in the breast of the committee, so we are having discussion and motions and comment on the bill from the committee. There'll not be any testimony at this time or during this hearing on this bill. Chair recognizes Representative Welch.
Thank you, Mr. Chairman. Going back to some discussion that we had yesterday about including a finding with respect to adult entertainment establishments which either sell, possess, or allow for the consumption of alcohol on the premises. We had some discussion. I withdrew the motion, and I wanted to try to get the language in a format that was easy for everyone to read and consider. And so in your folders, you should have AM 292403. And this is an amendment that I'm offering the committee to consider. This would go back at lines 18, which is in your findings of the bill, section 1-2. I'm sorry, isn't the title? And this would actually include in there the regulatory assessment on certain adult entertainment establishments and to provide for powers of. So it just picks up and places the regulatory assessment language in that caption. That was one that I had missed yesterday. Then the second part of this amendment is to revise findings on line 43, and this is to include the language associating adult entertainment establishments, those that allow the sale, possession, or consumption of alcohol on the premises. I'll wait. No, it's okay. So for those that are just joining us, we're looking at a proposed amendment, AM 292403 in your folder. So that would add the sale, possession, and consumption of alcohol. And this goes back to the general, to what we know in terms of our Supreme Court precedents in the state of Georgia, where they have tied and allowed for regulatory authority with respect to strip clubs and that provide alcohol on the premises or allow for consumption. So we are adding that in the findings under this amendment. And then on line 50, there will be a further amendment by adding the findings that you see here at line 50. And that picks up at the end of the sentence, line 50, and adds that the General Assembly acknowledges that many local governments in the state and other states have found dilatory secondary effects associated with adult entertainments as they're exacerbated by the sale, possession, consumption of alcohol in such establishments. The final revision is to adjust on page 1, it's on line 167, and that is page 6 of the bill. And this would add to the definition of an adult entertainment establishment to which the assessments would apply. And this would add at line 167, and we would rewrite that line there to be establishment where alcohol beverages of any kind are sold, possessed, or consumed, and then wherein. So that would then tighten up the overall legislation and the findings. I'd like to make that in the form of a motion, Mr. Chairman.
Is there a second on? Okay, that's on AM 292403.
Yes, sir.
Is there any objection to amendment AM 292403? Okay, all right. Representative Kennedy.
So the purpose of adding the connection into the alcoholic beverages is based on, you said, a Supreme Court case or Georgia Supreme?
Yes.
And the language that was used in the case was specifically in the holding that it needed to be connected to alcohol?
The Brookhaven case was in part decided on the issue of whether or not the strip club sold alcohol or did not sell alcohol. The city of Brookhaven was imposing an ordinance that would not allow the sale of alcohol at a strip club, and that was upheld. That ordinance was upheld based upon that distinction, and the underlying constitutional issue was dealing with the First Amendment and the ability of the strip club to opt out of being charged the regulatory fees and assessments and regulations by Brookhaven if you didn't provide the alcohol. But if you did, then you would be prohibited, actually. So, and that was a complete ban based upon that, whether alcohol was sold or not. So we're tracking, and the court had found that there was an exit route, if you will, an allowance for expression through nudity when there was no alcohol provided at the premises.
Okay. And what court? Sorry, what court was this?
The Georgia Supreme Court.
Supreme Court.
And then this also tracks the Texas legislation and the Texas decisions where Texas also allows that as an out from their regulatory oversight.
Representative Rakestraw.
Thank you, Mr. Chair. So I haven't been able to hear all the testimony, and I applaud what we're trying to do with the bill, but I do have some questions and concerns about, and I'm not sure if this is addressing it, and maybe you attorney types can help me with this, but about the people that get caught up in our sexual predator laws that really are not predators, but they get caught up in it because of the way we've defined that in the code. I know a lot of high school students, that have consensual relationships with other students, or in divorce cases, there's a lot of allegations made, and then once an allegation's made, they get caught up in stuff. And so I just want to make sure that we're not continuing to expand that. And then my other concern is, I definitely want to do something to help, but it seems like if we start funding it and dedicating funds, we get more of that and not less, and that concerns me. And if we're taking it from the establishments that we're saying are exploiting these kids, then it's kind of makes me feel like we're exploiting that too. We're becoming part of the pimp revenue that they're getting by asking them to pay for a portion of their profits to create this fund. So, I would like to make sure that what we're doing is going to curb the behavior and solve the problem, and not allow others to get caught up in our sexual predator laws and allow us to keep funding something that's going to continue, happening, because we keep dedicating funding to it. So those are my only comments. So I'd like to get feedback because I've had other committee meetings and haven't been here for all the testimony.
Well, thank you for your comment, Representative Rakestraw. The testimony that was provided by outside experts and practitioners and witnesses was provided yesterday and the two previous meetings we had before that. Today, what we're working on is we're working on this amendment, AM 292403, that's been proposed by Representative Welch, and this is I think that the point of the bill is to to first off set into place a safe harbor for those victims who have been victimized as a result of sex trafficking and human trafficking in the state of Georgia, and that's where this is going. And this is clarification language, and we're trying to get this bill moved forward to that point, and that's where we're headed today.
Okay, so, but in there's a piece here that talks about child abuse and domestic relations. So I don't know if it's actually doing anything to fix the code, and I don't really know what the fix is, so that people that aren't really predators aren't getting caught up in some of this stuff. But so, and his amendment is to work with the establishments on the fees that we're talking about assessing to them because we're saying they're driving a lot of this activity, is my understanding. But
Mr. Chairman, if I might, a couple of things. One, I think that we can address it sounds like you have an underlying issue with the fees overall in the bill, and the other part of it is dealing with the sexual predator issue, and neither of those are really in the amendment. So those aspects are with the bill, other portions of the bill. Mm-hmm. And Attorney Travis has said that she would address the issue about the sexual predator issue.
Okay.
But if we could, Mr. Chairman, if we could vote the amendment.
Just a second. Just a second.
I'd like to be recognized to call the question on the amendment 2403, Mr. Chairman.
Representative Oliver, call the question.
I move that we call. I request that the chair call a question on amendment 2403, so we can have a discussion on the more substantive matters at another later time today.
Thank you.
Ma'am. And the chair calls a question on the amendment 292403. Is there any objection to adopting the amendment as proposed by Representative Welch? Hearing none, the amendment is adopted. Moving on to the amendment by Representative Welch, AM 292404.
These are just clarifying issues that have been raised concerning the language in here. For example, we wanted to make sure that we were dealing with collection or remitting. So I'm going to be very quick. On lines 299 and 300, the language was collect and remit. In that sentence, we've changed that over to collect or remit. And then language dealing with the timing of when these fees would be due, we've moved that to April 30th of the calendar year as opposed to January 30th to allow for more time to get those tax statements together. And then the other one were just changes.
Let me just stop you right there, Representative Welch. Now, this is the purpose of moving from January, what was it, January 1st?
30th.
January 30th to April 30th was in order to allow the normal tax period to go past April 15th. Is that correct?
That's correct. Okay. Thank you, Mr. Chairman. And then also we've just changed the rule of regulations that for when the reports are required. That's the lines 309 through 312. And then in order to make it consistent with current code as to how the Commission of Revenue administers the collection of any assessments, taxes, or fees due to the state, we've made it conform to that under Title 48, and that's the amendments you see there is D and E under to lines 316 through 319.
Okay. All right. Is there any question or comment on the amendment 292404? Has got a motion do pass? Is there a second? A second. Okay. Is there any discussion or comment on the amendment? Hearing none, Chair calls the question on amendment to AM 292404. Is there any objection to adopting amendment as provided in AM 292404? Hearing none, the amendment is adopted.
Thank you, Mr. Chair. That was all that I had.
Okay, thank you. All right, that's all of the amendments. That brings us back to the original question. We had a motion do pass for the bill by committee substitute. As amended.
As amended.
By committee substitute.
It'll be, okay.
New committee substitute.
This will be the motion do pass by committee substitute. And thank you. And so all those in favor.
Did you want to get her questions answered?
Did we have any further questions from Representative Rexstraw?
So can we talk about how we're going to work on those other issues that I...
Okay. I think your first question was we have a problem with how to unring a bell that's been rung when there's an accusation put forth regarding a someone who's falsely accused of being a sexual predator.
Yes. Happens a lot. I hear a lot about, and it's typically in divorce cases or a consensual relationship with a high school, an 18-year-old with a younger high school student. But I've also seen it in politics in the county I live in. There's been, and so it's like once they get caught up in this, it's like once an allegation's made, they get caught up in and they're told to take a plea, and then they're on the list, and their lives are pretty much ruined, and it's a real shame that this is happening.
Well, let me refer you to counsel for this committee, Miss.
Because I would like to see us deal with the real predators and not, everyone that gets caught up in it.
Miss Jill Travis. Let's see which one.
Me too. I just am going to address two small, very small issues. One of the things that the first part of this bill does with respect to people being able to bring an action for childhood sexual abuse, one of the provisions that this bill does is it narrows what can be brought. And one of the things that it now excludes would be the Romeo and Juliet situation. So those causes of actions would go away. So this bill would be favorable in that regard. And with regard to the specific registration, that's sort of outside the scope of this bill. There's a little bit of it that's contained in it, only in the sense that Senator Unnerman wanted to make it clear that if someone was convicted of sex trafficking and sexual trafficking, that was included as an offense that was registerable. But that's the only aspect that is included in this bill.
My understanding, the Romeo and Juliet only deals with like 16 and 17-year-olds. So if it's like a senior that has a relationship with a freshman in high school, that would not be, they could still be on our predator list.
Well, that issue would be something that would have to be addressed on a different bill. This bill does not address that.
Okay.
As far as it goes with what you're relating. No. Representative Oliver.
I was going to just offer a comment on the Romeo and Juliet. It's a 3-year time span. And I've also had cases in my law practice where there's false allegations, and that's a real issue in some isolated cases. None of this bill relates to consensual sex. None of this bill relates to the kind of shaming activities that go on in various entities. This bill only relates to a very narrow commercial area of trafficking.
Okay, and then my second issue with that is, if we start creating a government entity to start funding this, then, it feels. Are we going to get more of that behavior?
I think that the funding is for services for children.
Mm-hmm.
But I think there's a fair philosophical question about assessing adult entertainment for the purpose of providing services for children. I support that, but I recognize that's a fair conversation.
And I'm not a fan of the adult entertainment industry. Don't get me wrong. I don't really like, levying additional assessments on any business. And though like I said, I'm not a fan of that industry, but it does concern me that when we start creating government funding for things, we tend to get more of it rather than less. So, can anyone speak to experience with that?
I don't happen to believe that, it's my personal, knowing what we project about the collection of possible assessments against the adult entertainment, that will create more of an activity of sexual trafficking or sexual exploitation. And I think what it'll do is help prevent further sexual exploitation of children who, by services of treatment that will serve to cure the nightmare crisis for individual children. The bigger picture for me, and I'm only speaking personally, and the chair can cut me off at any point, he's ready to move on, but
Go right ahead.
Our services for children who are in crisis based on neglect, based on abuse, based on left at home burning the fire down, is all totally underfunded. I don't believe that this pot of money to provide services for sexually exploited children is going to be overfunded for the purpose of providing services. We have so many gaps in so many variety of ways. My concern is that this is one way to help fill one small gap. Mr. Chairman, what's our posture right now?
We have a motion due pass, and we're on we're at the original question.
Okay. Is it too soon to call the question?
It's not.
No,
Well,
I'd like to call the
just
question.
a second. Okay. There's a motion to call the question, and the chair calls the question hold on. Okay. Is there any other comment or discussion from the committee? Seeing none, chair calls the question, and all those in favor of the of LC 29662-1S as a committee substitute would indicate, as amended. All those in favor of the bill, passage of the bill, indicate by saying aye. Aye. All opposed, no.
No.
Okay, the ayes have it. The bill passes or receives a recommended due pass recommendation. God knows. Okay, now. Yeah. Okay. Okay. All right, moving on to Senate Resolution 7, that'll be LC 296624S. This is the funding mechanism that will be required in order to have dedicated funds, and this requires an amendment to the Constitution. Okay. Is there Do I hear a motion? All right. Is there any discussion of LC 296624S by the committee? Okay. Hearing none, chair calls the question. All those in favor of due pass recommendation for LC 296624S indicate by saying aye. Aye. All opposed, no. No. The ayes have it. Senate Resolution 7 receives due pass recommendation from the committee. Okay. Okay. Did I call? That's the only number we got, right? Okay, we have one other bill that's been added to the agenda, which is Senate Bill 64. We're going to take a 5-minute recess till that bill can be distributed to the committee, and then we'll take that bill. We're in recess for until 4:40. Juvenile Justice Committee, and we're going to work on Senate Bill 64. This is the Senate version of House Bill 264, and this is related to domestic relations, vital records. This eliminates the administrative legitimation. Excuse me. Thank you. And acknowledgement of paternity. And this was the bill that this committee, well, this is the corollary bill, I guess is what I would call it, that was filed in the Senate, carried by Senator Huffstetler. What we're going to do, what Chair would like to do with this, we have already dealt with these issues. We have addressed the subject matter, and at the appropriate time, I'll accept a motion. And you got a motion and a second. Motion do pass in a second. Okay. Before we do that, let's see. Okay, you got it. Before we do that, I would like to allow some comment from. Before we move on to the vote, I would like to allow some comment from any experts. I know we have Judge Tilley. Thank you for coming here today, Judge Tilley.
Thank you for putting on the calendar. I really appreciate that. I don't have to be heard on it. If everybody's good, I'm good.
Certainly. Thank you, Judge Tilley. It's always a privilege to have members of the judiciary here, and I certainly appreciate what you do in the judiciary and being with us. So without further ado, and being that we have addressed this exact bill and these exact issues, do I hear a motion? Now the motion do pass. Was that as committee substitute, taking the language out of House Bill 64, inserting it in Senate Bill 64?
House Bill 264.
Okay. All right.
House Bill 264, Mr. Chairman. Language out of House Bill 264.
Thank you. I stand corrected. Language from House Bill 264, which was passed out of this committee to the rules, will be inserted as a substitute for Senate Bill 64. That's the motion that's the do pass, right? Okay. So, all right. Is there any question or comment regarding what we're doing here or any substance of the bill?
I'm just not sure I understand what you're saying.
Okay. We passed out House Bill 264, Representative Quick's bill. And when she filed her bill for this, that covered the same information and issues that are were addressed in House Bill 264. In the Senate Bill 64, the one that's before us today, was also filed. The Senate passed out this before crossover day, and it made it over here. However, House Bill 264 did not make it out of rules and on the floor and passed out to the Senate before crossover day. So what we're doing, in lieu of rehashing the exact issues and subject matter, we're going to take the language that we've already perfected, we're going to insert it here in Senate Bill 64 and move it on to rules and then work through the process. Does that clarify things? Thank you. Okay, who we got? Representative, golly, it's one of those days. Representative Evstration.
Thank you, Mr. Chairman. I appreciate the work the committee's done. I'm just not familiar with the language, and I just would request an opportunity to review the language and have a chance to see if I do have any questions for the judge before voting on it. That'd be my request.
How much time you need?
Oh, I don't assume it would take that long, but I just would appreciate the chance to do that. I know Representative Quick's worked very hard on this matter, but just would want to take a look at it before voting.
Well, this is the language we're going to be substituting in on Senate Bill 64, or that the motion is on, would be the language that this committee has passed out previously.
Yes, sir.
Okay. Need a 5-minute break?
That'd be fine. Thank you.
We'll take a 5-minute break till 4:53. Committee is Senate Bill 64 by committee substitute, and the bills on the breast of the committee. Is there any further discussion or comment on the bill? Yes, sir. Representative Evstration.
Thank you, Mr. Chairman. If I could direct the committee's attention to line 148 through 156. Mr. Chairman, my concern is specifically in line 149, the word shall, and the apparent mandate that's being placed squarely on hospitals, public and private, as a result of this legislation, as I understand, also exists in HB 264, carried by Representative Quick. And my only, I guess, thoughts are that if shall were to be changed to may, would there be some protection for hospitals in anticipation of litigation or action if parents failed to complete the documents as required, that it wouldn't land squarely on the hospitals as a matter of principle, opposed to mandates in the area of health care and concerned about this. And I've spoken with Representative Quick about the matter, and my concern continues to be an issue. Thank you.
Representative Quick.
Thank you, Mr. Chairman, and just maybe for the benefit of committee members that might not have been at the meeting where we passed out House Bill 264, this is an initiative of the Georgia Child Support Commission. And so I carried the bill only so that Representative Tim Barr wouldn't have to discuss anything about child support or law-related issues, since he and Ronnie Mabra are our designees in the House, of the governor's appointees, I should say, to the Georgia Child Support Commission. And the reason, of course, we're dealing with Senate Bill 64, Senator Huffstetler and Senator Jones are the Senate appointees to the Georgia Child Support Commission. But this was really a summer-long and maybe longer and into the fall series of meetings. They took testimony. There were public hearings that the Child Support Commission went through. And if I get it wrong or don't give it justice, Judge Tilley can jump in here and explain it to the committee. But sort of everybody came to the table and to try to deal with this issue, which was in large part, because the requirement that there is a possibility for an administrative paternity determination in the first place is something we are required to do in order to continue to receive TANF funding from the federal government. And somehow, when it was done initially, legitimation got in there, and that's not required by the federal government because not every state has a legitimation statute like Georgia does. And so the issue about the acknowledgement, once it is once it is signed at the hospital, obviously this has to be dealt with at the hospital. That's been the requirement for some period of time. But the problem was the document itself was not getting to vital records. And so there had to be a mechanism by which, once this administrative determination of paternity was made, there could be a record of it. And correspondingly, once it was filed with vital records, lawyers weren't able to access it, and neither were the parents. And so that's why the cleanup language is in this bill in this way. It was worked on, and the Georgia Hospital Association has been involved in the negotiations and work on the bill. And so about all I can say is my understanding is that all the changes they have requested were made. So that's my limited understanding of those interactions anyway. And in particular, on the Senate side, a lot of the language that we dealt with in the amendment process in 264, which didn't contain the result of that work, came from negotiations and work with the Hospital Association. So that's the background of that, Mr. Chairman. I understand Representative Efstration's point, but we have to have a way to get the determination of paternity to vital records.
Representative Welch.
Thank you, Mr. Chairman. And I'll direct these at Representative Quick because she had responded to the bill before. But is it not true that the mandate here, it is a mandate, and it is simply that the hospital would provide this acknowledgement form to the potential father to acknowledge paternity, and then if he doesn't sign it, then that's the end of the matter for the hospital. But if he does sign it, then there would be the mandate to file. Is that correct?
That is correct, Representative Welch, and I'll just, for completeness and clarity, say that the form is what then provides questions and information about administratively establishing paternity and the availability of a judicial determination of paternity to the parents.
And Mr. Chair, if I may follow up, is it not true also that our Department of Human Services has just recently passed through this committee legislation that would authorize and allow the department by mandate to compel testing, genetic testing of potential fathers in order to ensure that fathers that have procreated and created children are now in the business of owning up to that financial responsibility, so that that's less burden on the state taxpayers?
That is absolutely correct, Representative Welch. And to that point, this requirement is in fact so that the state can then seek reimbursement for the TANF funding. I mean, that's part of this requirement, is to try to make sure the records are there, and that if this paternity determination has been made, you can access this and proceed along to collection, which is the other piece of this not contained in this legislation and not part of what the Child Support Commission is bringing forward.
I respect Representative Efstration's identification of this as being a mandate, and it probably does impose some financial burden on the hospitals, and I guess that's just a policy question we need to make as to whether we want to do that. But I do find it consistent with some of the previous legislation we've considered.
Yes, sir.
Representative Efstration.
Thank you, Mr. Chairman. I'll be very brief. I know the hour's late. If I might direct these questions toward Representative Quick, just so I can fully appreciate the testimony that was just given. Representative Quick, you acknowledge that this is a mandate on hospitals in Georgia, public and private?
I believe it is.
Okay.
I believe it is a shall.
And as I understood your testimony, it's your testimony the mandate only extends to providing the form to the mother and father if the father's present.
Well, it extends to lines Extends to all of Section 5.
Yes, ma'am. So that would also include the responsibility. The mandate would also include the responsibility to file the signed acknowledgement as well. Correct?
I feel like I'm being cross-examined, but yes.
Well, no.
Now I know how people feel when I ask them questions, Representative Efstration.
We have the unique.
Just answer yes or no.
It's like in this committee when I was questioning a prosecutor. I don't think I've ever had that experience.
The answer to your question is yes.
Yes, ma'am. And also, and I know that this is an opportunity to get some good information here, but the mandate would also extend to providing copies back to the mother and father after sign, correct?
Yes.
And as you stated, the mandate would also include other provisions of Section 5. Is that right?
Section 5 outlines the requirements.
Yes, ma'am.
For the hospital.
And I've earlier in discussion raised concern or recognition of the potential for civil litigation as a result of the hospital's failure to adhere to the letter of the statute. Would you agree that that's the case since we have the shall language?
You mean assuming that someone is damaged by the failure to file a signed form that someone then has in their hand?
Yes, ma'am.
I guess theoretically that's possible. Anybody can sue anybody for anything.
Thank you, Mr. Chairman.
Okay. Any further discussion or comment on the bill? Okay. All right, now we're back to the original question, which is passage of the bill by committee substitute. Okay, and the chair calls the question. All those in favor of the bill of the committee substitute, let me get to it. SB 64. By committee substitute. All those in favor of the bill indicate by saying aye.
Aye.
All opposed, no. No. Bill carries and carries a due pass recommendation and is on the rules. Where?
Yes.
Yeah, it's committee substitute.
Yeah, it is committee substitute. The motion was made.
Yes, we got it. Yes, we did. Yeah, yeah, absolutely.
Did you point that out, or did Chairman Gold?
Okay. Yeah. Cool.
I need some signatures.
Chuck, I was just wondering if I was the recipient of all that frustration from being in Judy non-civil presenting so many bills this year.
Not at all.
SR 7. Then we got, this one is
Bill 8.
SR 8. Yep.
We adjourn, sir.
This meeting is adjourned.